Supreme Court nominations. Article 2, Section 2 of the Constitution states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. The President usually will consult with senators before announcing a nomination. When the President nominates a candidate, the nomination is sent to the Senate Judiciary Committee for consideration. The Senate Judiciary Committee holds a hearing on the nominee. The committee usually takes a month to collect and receive all necessary records from the FBI and other sources about the nominee and for the nominee to be prepared for the hearings. During the hearings, witnesses, both supporting and opposing the nomination, present their views. Senators question the nominee on his or her qualifications, judgment, and philosophy. The Judiciary Committee then votes on the nomination and sends its recommendation that it be confirmed, that it be rejected, or with no recommendation to the full Senate. The full Senate debates the nomination. The Senate rules used to allow unlimited debate, a practice known as filibustering, and to end the debate, it required the votes of 3/5 of the Senate, or 60 senators, known as the cloture rule. In April 2017, the Senate changed this rule and lowered the required votes to 51 to end debate on Supreme Court nominations. This was commonly called the nuclear option. When the debate ends, the Senate votes on the nomination. A simple majority of the senators present and voting is required for the judicial nominee to be confirmed. If there is a tie, the Vice President, who also presides over the Senate, casts the deciding vote. How long does it take to confirm a Supreme Court justice? This chart shows 119 nominations, even though only 115 individuals have served on the court, because 4 men were confirmed twice, first as associate justices, and then again when they were elevated to Chief Justice. The chart shows the days from nomination to Senate confirmation. You can see that 8 justices were confirmed on the same day they were nominated, 19 justices within 1 or 2 days, 36 justices within 3 to 10 days after their nomination, 17 judges within 11 to 20 days, 8 within 21 to 30 days, 11 within 31 to 50 days, 8 more within 51 to 75 days, 10 in 76 to 100 days, and 2 justices were confirmed over 100 days after their nomination. As you can see on this chart, most of the justices have been confirmed within 30 days of their nomination. This chart shows that the Supreme Court justices' confirmations generally take longer now than they used to. If you look around 1780 to 1800, even up to 1820, all of the nominations were confirmed within 10 days. You see the first longer nomination within 30 days in the 1820s, and one that took almost 80 days, but still up until 1840, even 1860, most of the nominations were confirmed within 10 days. But if you look over at the right side of the chart, you can see that between 1960 and 2020, over the last 60 years, many of the nominations have taken much longer. 73 days for Stephen Breyer, 82 days for Samuel Alito, 99 days for Clarence Thomas, 88 days for Brett Kavanaugh, 87 days for Elena Kagan, Sonia Sotomayor in 66 days, Neil Gorsuch in 65 days, and Amy Coney Barrett and John G. Roberts, a little bit less than that, 23 days for Roberts and 27 days for Barrett. But it has become relatively common for confirmation processes to take 2 or 3 months. A little bit about the history of Supreme Court nominations. As the first president, George Washington successfully appointed 10 justices to the Supreme Court. The only time the Senate rejected a Supreme Court nomination from Washington was when he tried to make former Associate Justice John Rutledge the Chief Justice in 1795. Although the Senate was controlled by Federalists, the party with which Washington was unofficially aligned, it rejected Rutledge over a speech he'd given opposing the Jay Treaty, which the Senate had recently approved. The first president to have real difficulty filling Supreme Court vacancies was John Tyler. Critics dubbed Tyler his accidency because he was the first vice president to assume the office after a president's death. Tyler had been William Henry Harrison's running mate on the 1840 Whig Party ticket. When Harrison died after only 31 days in office, the Whigs weren't happy to be stuck with Tyler. Within a year, all but one of Tyler's cabinet members resigned, and the Whigs expelled him from the party. When it came time to fill Supreme Court vacancies, the Whig-controlled Senate only confirmed 1 out of the 5 men Tyler nominated. The Senate rejected, voted to postpone, or just ignored his other nominations, marking the first time the Senate had so forcefully opposed such a large portion of a president's Supreme Court selections. The Senate strongly opposed Ulysses Grant's 1874 nomination of Caleb Cushing for Chief Justice. Cushing asked Grant to withdraw his name from consideration before the Senate could even vote on him. 73-year-old Cushing was a former attorney general who had criticized abolitionists and written an introductory letter to Jefferson Davis while he was president of the Confederacy. Cushing had also supported the Supreme Court's 1857 Dred Scott decision that black Americans weren't U.S. citizens, a decision Congress invalidated with the 1866 Civil Rights Act and the 14th Amendment. In 1887, Democratic President Grover Cleveland nominated Democrat Lucius Quintus Cincinnatus Lamar, the first former Confederate nominated to the Supreme Court. Lamar was a former member of the House of Representatives who had resigned in 1860 in order to help Mississippi secede, and then became a colonel in the Confederate Army. He went back to Congress between 1873 and 1885, first retaking his old House seat and then rejoining the Senate. Republicans held only a narrow majority in the Senate. Even though his Civil War record and ties to railroad companies made 62-year-old Lamar an unpopular choice for the Supreme Court, the Senate confirmed him by 32 votes to 28. 16 senators didn't bother to vote. Lamar served on the court until his death in 1893. Maybe the easiest confirmation in the court's history was that of Edward Douglas White. On February 19, 1894, President Grover Cleveland nominated White, then a senator from Louisiana, as an associate justice. The Senate confirmed White that day on a voice vote. On December 12, 1910, President William Howard Taft picked White to be the new Chief Justice. Again, he was confirmed the same day, and again on a voice vote. White served on the court for more than 27 years. Byron White. Byron White marks a dividing line, perhaps, between the days when it was easy to be confirmed and quick, and when it became slower and more difficult. From 1789 to 1941, 6 other justices, besides White, were confirmed on the same day they were formally nominated. In fact, of the 115 people who've served on the court throughout its history, more than half were confirmed within 10 days of their nominations. The most recent, Byron White, joined the court in 1962 following an undramatic 8-day confirmation process that ended in a voice vote. It wasn't until the 1916 appointment of Louis D. Brandeis that the Senate Judiciary Committee even held public hearings on a nominee, allowing witnesses to argue for and against Brandeis's confirmation. Brandeis, the first Jewish justice, was controversial because of his legal activism in support of workers' rights and social reform movements, and in opposition to banks, railroads, insurers, and big business generally. After 125 days, still the record for a confirmation battle, Brandeis was confirmed on a 47-22 vote. From the birth of the Republic up to the early 1950s, the average span between nomination and confirmation was 13.2 days. But from Earl Warren in 1954 to Amy Coney Barrett in 2020, the time from nomination to confirmation has averaged 54.4 days. The modern era of contentious Supreme Court nominations really dates to the late 1960s. Between 1789 and 1965, presidents made 130 nominations to the court, including some men who were nominated multiple times, and a few cases of associate justices nominated to be Chief Justice. Of those, 68 were confirmed on voice votes and served on the court, and 27 others were confirmed by comfortable margins. Only 3 justices were confirmed with a margin of fewer than 10 votes. The Senate rejected 9 nominations, and 15 others either failed due to Senate inaction or were withdrawn, for an overall failure rate of 18.5%. One man, Reuben Woolworth, was nominated 3 separate times in 1844, but the Senate never acted on him. Since 1965, there have been 28 Supreme Court nominations, a quarter of which have failed. 3 nominees, Clement Haynesworth, G. Harold Carswell, and Robert Bork, were rejected by the Senate. 3 others had their nominations withdrawn due to Senate opposition, and the Senate refused to act on one, Merrick Garland. Of the 21 successful nominees, 4 were confirmed by a margin of fewer than 10 votes. The other 17 were confirmed by more comfortable margins. Nixon nominated 2 men for the Supreme Court who each had a history of supporting segregation. Clement Haynesworth Jr. had supported a decision by Prince Edward County, Virginia, a county that chose to close schools rather than integrate them after the Brown versus Board of Education system ruled that school desegregation was unconstitutional. Civil rights activists and labor activists criticized his record and pointed out that he had had a conflict of interest in one of the cases he decided. The Senate rejected Haynesworth in 1969. Nixon nominated G. Harold Carswell after Haynesworth was rejected. Critics claimed Carswell had a mediocre career, leading one Republican senator to say, even if he is mediocre, there are a lot of mediocre judges and people and lawyers, and they are entitled to a little representation, aren't they? Worse, when he was running for the Georgia legislature in 1948, Carswell had said, "I yield to no man as a fellow candidate or as a fellow citizen in the firm, vigorous belief in the principles of white supremacy, and I shall always be so governed." Civil rights groups highlighted this statement and his support for segregation, and the Senate rejected him as a Supreme Court justice. One of the reasons that Supreme Court nominations have become so highly controversial and contentious in the last 50 years or so is because of this decision, Roe versus Wade, probably the most controversial decision of the 20th century. In this case, the Supreme Court ruled that the Constitution protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. The decision struck down many U.S. federal and state abortion laws. It involved the case of Norma McCorvey, known by the legal pseudonym Jane Roe, who in 1969 became pregnant with her 3rd child. McCorvey wanted an abortion but lived in Texas, where abortion was illegal, except when necessary to save the mother's life. McCorvey's lawyers, Sarah Weddington and Linda Coffey, filed a lawsuit on her behalf in U.S. federal court against the local district attorney, Henry Wade, alleging that Texas's abortion laws were unconstitutional. A 3-judge panel of the U.S. District Court for the Northern District of Texas heard the case and ruled in her favor. Texas then appealed directly to the U.S. Supreme Court. In 1973, the Supreme Court issued a 7-2 decision in McCorvey's favor, ruling that the Due Process Clause of the 14th Amendment provides a right to privacy that protects a pregnant woman's right to choose whether to have an abortion. It also ruled that this right is not absolute and must be balanced against the government's interests in protecting women's health and prenatal life. The court tied state regulation of abortion to the 3 trimesters of pregnancy. During the first trimester, governments could not prohibit abortions at all. During the second trimester, governments could require reasonable health regulations. During the 3rd trimester, abortions could be prohibited entirely so long as the laws contained exceptions for cases when they were necessary to save the life or health of the mother. In 1987, President Ronald Reagan nominated Judge Robert Bork for Associate Justice of the Supreme Court. Bork was a judge on the United States Court of Appeals for the District of Columbia Circuit, to which he had been appointed by President Reagan in 1982. Bork's nomination precipitated a contentious Senate debate. Opposition to his nomination centered on his perceived willingness to roll back the civil rights rulings of the Warren and Burger courts, and his role in the Saturday Night Massacre during the Watergate scandal. To pro-choice legal groups, Bork's originalist views and his belief that the Constitution does not contain a general right to privacy were viewed as a clear signal that should he be nominated to the Supreme Court, he would vote to reverse the court's 1973 decision in Roe v. Wade. Within 45 minutes of Bork's nomination to the court, Senator Ted Kennedy delivered a strong condemnation of Bork in a nationally televised speech on the Senate floor. He said, "Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters, rogue police could break down citizens' doors in midnight raids, and school children could not be taught about evolution. Writers and artists could be censored at the whim of the government, and the doors of the federal courts would be shut on the fingers of millions of citizens." The Senate rejected Robert Bork's nomination to the Supreme Court by a roll call vote of 42 to 58. He is the most recent Supreme Court nominee to be officially rejected by the Senate. Bork's margin of rejection by the Senate remains by percentage the third largest on record and broke a 142-year record for largest defeat of a Supreme Court nomination. In 1991, President George H.W. Bush nominated Clarence Thomas to replace Thurgood Marshall, who had announced his retirement. Thomas was a judge on the U.S. Court of Appeals for the District of Columbia Circuit at the time of his nomination, a position President Bush had appointed him to in 1990. The nomination proceedings were contentious from the start, especially over the issue of abortion, and many women's groups and civil rights groups opposed Thomas because of his conservative political views. Toward the end of the confirmation process, sexual harassment allegations against Thomas by Anita Hill, a law professor who had previously worked under Thomas at the United States Department of Education and then at the Equal Employment Opportunity Commission, were leaked to the media from a confidential FBI report. The allegations led to a media frenzy into the reopening and televising of hearings held by the Senate Judiciary Committee before the nomination was moved to the full Democratic-controlled Senate for a vote. Thomas was confirmed by a narrow majority of 52 to 48. In 2018, President Donald Trump nominated Brett Kavanaugh to the Supreme Court to succeed retiring Justice Anthony Kennedy. Kavanaugh was on the U.S. Court of Appeals for the District of Columbia Circuit, a position he was appointed to in 2006 by George W. Bush. The Senate Judiciary Committee questioned Judge Kavanaugh and heard witness testimonies concerning his nomination to the Supreme Court over the course of a 4-day hearing in September 2018. Several days later, it was revealed that Christine Blasey Ford had written a letter to Senator Dianne Feinstein in July, accusing Kavanaugh of sexual assault while they were both in high school in 1982. The committee postponed its vote and invited both Kavanaugh and Blasey Ford to appear at a public hearing. Meanwhile, 2 other women accused Kavanaugh of separate past instances of sexual assault. Both Kavanaugh and Blasey Ford testified before the committee on the same day. The following day, the nomination was forwarded to the full Senate on an 11-10 vote. Then, following a supplemental FBI investigation into the allegations, the Senate voted 50-48 to confirm Kavanaugh's nomination to the Supreme Court. On September 26, 2020, President Donald Trump announced the nomination of Amy Coney Barrett to the position of Associate Justice of the Supreme Court to fill the vacancy left by the death of Ruth Bader Ginsburg. The Senate received word from the President when a Supreme Court nomination becomes official on September 29. At the time of her nomination, Barrett was a judge of the United States Court of Appeals for the 7th Circuit in Chicago, Illinois. Democrats rebuked Republicans and accused them of hypocrisy concerning this nomination, stating that they had violated their own rule, which they set in 2016, when they refused to consider President Obama's nomination of Merrick Garland more than 9 months before the end of his term. The 35 days between the nomination and the 2020 presidential election marked the shortest period of time between a nomination to the Supreme Court and an election in U.S. history. On October 26, the Senate voted to confirm Barrett's nomination to the Supreme Court, with 52 of 53 Republicans voting in favor, while Susan Collins and all 47 Democrats voted against. On January 26, 2022, NBC News reported that Justice Breyer planned to retire at the end of the court's current term. The next day, Biden reiterated his intention to keep a campaign promise to nominate a black woman for the first Supreme Court opening. A poll a few days after found that 76% of Americans believed Biden should consider all possible nominees, while a substantially smaller share of Democrats at 54% said the same. Only 23% said he should follow through on his pledge to only consider nominees who were black women. Some Republicans criticized Biden's pledge to nominate the first black woman to the court as hypocritical because in 2005 he had threatened to filibuster Janice Rogers Brown, a black conservative judge on the D.C. Circuit Court of Appeals, if she was nominated to the Supreme Court. On February 25, 2022, President Biden announced that he would nominate Ketanji Brown Jackson to the position of Associate Justice of the Supreme Court to fill the vacancy by Stephen Breyer. Jackson, a former law clerk of Breyer, was a judge on the U.S. Court of Appeals for the District of Columbia Circuit, having been appointed by Biden in 2021. Jackson is the first black woman in U.S. history to be nominated to serve on the U.S. Supreme Court. Her nomination was sent to the Senate on February 28, and her confirmation hearings were held by the Senate Judiciary Committee from March 21 to 24, 2022. The Senate confirmed her on April 7, 2022 by a 53-47 vote, and she took the oath of office on June 30, 2022.